going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, got anything to say?
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Hope you guys had a great day. Hope you had a great day. I've got some court tonight. I've got some fun court tonight. I've got three clips. Let's see. We have Judge Tammy, Judge Johnson, and we have Judge Perkins. There we go. I knew I would figure it out. I hope you guys are doing well. You guys want to watch some court? Let's watch some court. I saw someone said the Judge Boyd drama was wild. Yeah, that was. I I can't believe people are still going up to her and saying, "Are you advertising? Are you doing this for YouTube?" Oh man, that video is not part of my hearing tonight. My hearing tonight. That video is not part of my video tonight. I do have it. Maybe at the end I can figure out a way to play it, but it's not an MP4 format, so it's going to be hard to play. But I might be able to share my screen and show it. It's not a very long clip. It's only about 6 minutes long, so we'll see. We'll see if there's time. I don't know if there's enough time. Gonna go Home Depot, pick out some curtains. All right, I'm rambling. Let's watch some court. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
This is case number 24SO03327A OM City Southville versus Darius Aaron. Are you calling this man?
Mayor Rubio, on behalf of Mr. Aaron, please come up and state your name, sir.
Name is Darius Aaron.
Okay, Mr. Aaron, you're here for a pretrial. Charge here is retail fraud, third degree. It's a 9-day misdemeanor with up to a $500 fine. You certainly have a right to have a trial by judge, by jury. Give me this copy with a lawyer to represent you.
I'm trying to. I don't know what you're saying, Mac. I'm just here to try to decipher the second actuality in Colin's intro, which is indecipherable, but to me it sounds like Chunky, the United States. I know that isn't, but I don't know what you're talking about. I don't. Let's see. What does it start with? It's me saying what's going on, and then we have Judge Slavin saying shout out to Colin, and then I muted him because he says my last name. Then everyone else who's cool with Colin, and then what would we go? Shemke, got anything to say? Shemke, got anything to say? Is that what you're trying to figure out? All right. Anyways, pause too long. Let's go.
You understand that?
Yes.
All right. So the offer is what? Plead guilty under Hyden. All right. So let's go over the constitutional rights of the next slide. Can I have the Rogers, please? The Rogers. You have that one?
Okay.
Okay, that'll be next.
Yeah, he's on.
So we're gonna go over all the constitutional rights that you got, that you really have right now, that you're getting ready to give up because you're pleading today. If you understand these rights, all you need to do is say yes as we go over these rights together. Okay, so we're gonna start with.
Happy birthday, Sharky! Happy birthday! Hope you have a great day. Thank you so much for spending a little bit of time on your day with us. I hope you had a great day, and yeah, here's to another great year. Happy birthday, man.
The fact that you have right to trial by judge, by jury with a lawyer. You understand you're gonna waive that.
Yes.
At the trial, you have the right to subpoena witnesses, meaning to ask the court to order witnesses to come forward to testify for you. You understand you're gonna waive that.
Yes.
You have a right to question through your lawyer witnesses brought against you by the prosecution. You understand you're gonna waive that.
Yes.
You have a right to testify on your own behalf, but if you choose not to, no one can hold it against you. You understand you're waiving that.
Yes.
Also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt by the prosecution. You understand you're waiving that. If you're on probation or parole, when you plead today, it could be considered a probation or parole violation. You understand that?
Yes.
You have read and signed the advice rights form going over with your lawyer. that right?
Yes.
Have any questions?
No.
Understand if I do accept the plea, you will not have a trial, you'll give up these rights.
Yes.
You also understand the possible penalties involved with the retail fraud.
Yes.
And you wish to proceed that charge.
Yes.
You also understand if you try to appeal and you have to have a right to appeal. And if you try and you do have a right, you want to appeal, you'd have to do so within 21 days of the sentence and request a lawyer for the appeal if you wanted a lawyer within 14 days of sentencing. You understand that?
Yes.
And you understand this charge of retail fraud third degree? And you still wish to plead guilty to it?
Yes.
Anybody force or threaten you?
Yes, ma'am.
Been promised anything other than what was stated today on the record? Are you pleading freely voluntarily?
Yes.
Is it true this occurred September 9, 2024 in the city of Southfield?
All right, before I get into this, we just went through all the boring court stuff real quick. This one's this one's kind of funny because his story is just dumb. This guy probably has the worst shoplifting story I've ever heard. Craig, thank you so much for the 5 months. Finally caught it live. Well, I'm happy you're here. I'm glad you caught it. Thank you so much, Craig. Thank you for the 5 months. Sashina rolling in with 13 months. Thank you so much, Sashina. OG. Thank you, Sashina. And fantasy. There's 1 week left. 1 week of the season left. I am in 5th place. Top 4 teams make the playoffs. I'm in 5th place. So Team Skeptic's in 1st place. He made the playoffs. He can't be knocked out. 2, 3, and 4. Ranked 2, 3, and 4 are all. What is the record? They have 9 wins. I don't know how many losses that makes them, but all 3 of them have 9 wins. I have 8 wins. I have the 2nd most points in the league. So Team Skeptic has the most. I have the 2nd most. So if any one of those top 3 teams or 3 out of the top 4 teams lose this week and I win, then I will pass them. So I need to win and I need one of those 3 teams to lose. I am not playing any of those 3 teams. So I'm not in charge of my own destiny. So it's going to be an interesting weekend. Okay. Back to the dumbest story ever.
At 28650 Telegraph Road near 12 Mile Road. And what store was that?
It's Lowe's, Your Honor.
Lowe's? All right. Was Lowe's open to the public, offered merchandise for sale on that date and time?
Yes.
And did you try to take items offered for sale by Lowe's without paying for it? Or did you work there at the time or something?
He did not work
Did you
there.
change price tags? What did you do that was a retail theft?
Actually,
I was just gonna indicate, sir, did you leave the store of Lowe's with items and not pay for them?
yes.
I just asked, did he take items without paying for it? He looked at me like, no. Sir, do you understand what I asked you?
Yes, I do.
Did you take items offered for sale by mayor, Lowe's without paying for them? You said no at first. All right, what did you take?
I left. What wasn't paid for is.
So did you go through the self-checkout or something?
No,
You
ma'am.
went through the regular checkout?
No.
How did you take the items without paying? And you paid for some other items? What did you
No.
do? You tell me what you did.
I exited the building without paying for items.
So you just went out the door, did not attempt to pay?
No,
And you knew you were stealing those items?
no,
You didn't know you were stealing.
no.
How did you not know you were stealing items if you went out the door without paying for them?
I knew I was leaving not during the time, but it was a misunderstanding at the time.
What was the misunderstanding?
I was with my autistic brother, and I had a guy that wasn't dressed in dress code. I didn't know who he was.
A Lowe's employee.
And the Lowe's employee, he wasn't dressed in Lowe's, and I should say Lowe's. That's
So what?
Basically what I'm trying to say. He approached the basket as we was leaving out of the
Well, why were
building,
you leaving out of the building with items that you had not paid for?
because I told a lady that I was actually buying concrete bags, and the concrete bags were loaded outside. I didn't fully exit the building with the bags.
So what was your intent to go outside?
My intention was to go to my vehicle, bring it back around and load my vehicle up with the concrete
Why
bags.
would you
I
do
was
that
doing.
if you hadn't paid for anything? Wouldn't it make more sense to pay for the concrete bags first?
Yes,
And
it would
everything
have.
else in your basket,
Yeah,
then go get your car loaded in?
yes, it would have, but everything led to, everything happened all at once.
So you're saying you did not intend to steal?
No, not.
Your Honor, if I may, when he first went to the store, he indicates to me that he did not, it wasn't his intention upon arriving at Lowe's to steal. I told him that that happens a lot, sometimes people make a decision in the moment. But then when they did leave the store, the Lowe's employee approached, it's on video, and tried to, as for lack of a better word, kind of snatch the basket back from, and his brother had the basket in his hand, but Mr. Aaron was standing right there. And at that point, on the video, you can see, and his brother is a rather large man, he then goes towards the Lowe's employee. Then Mr. Aaron and his brother take the items out of the cart. They go, they get in their vehicle, and they drive off.
Is that true? They tried to stop you and then you still took the items out of the cart, got put your vehicle and drove off. But you didn't intend to steal that?
So what it is, I know it sounds crazy.
It does sound crazy.
Exactly.
Nobody would take items off when the employee is trying to tell you something and you know you haven't paid for it. Who then removes the items from the basket, gets in their car and drives off?
Now, can I tell you, we did not know the guy that came to.
So
the
why would you
basket.
do it regardless of who it was? Why would you get in your car and drive off with unpaid merchandise?
I will state, Mr. Aaron indicates to me that at the time, he was a bit concerned about his brother getting into a physical altercation. And so.
I don't care about that. I want to know why he left. He should have left everything there and taken his brother home. Why would you walk out with the merchandise of Lowe's if you were concerned about your brother getting into an altercation and you knew you didn't pay for anything?
At that moment, my mind wasn't on the bags.
But then
we
why,
still
when
left
the
with
person tries to grab the basket, if that's true, would you all try to grab the basket back and take the items out? Why did you just leave it there and walk out?
I don't think.
Because right now, this sounds like a retail theft to me.
Yes.
But if you want a trial on it, we'll give you a trial. I don't know if you can convince a jury of that little story you were trying to tell me.
No, it's not a story. I was telling you.
Well, you have to state that you intentionally, knowingly and intentionally stole those items.
Yeah.
That's what you have to say to plead. If you can't say that.
I told you, this story is awesome. I need the quick pause because Heather, the original member, 14 months. That is what we're up to now. Thank you so much, Heather. I appreciate it. Go get some rest. Heather hasn't been feeling well, guys. She needs to get some rest. Sleep time. Sleep time.
Then you have to have a trial. And I'm not hearing him say that. I'm hearing him saying something about his autistic brother had something to do with it, and he was going to get some concrete, and it just doesn't make any sense. But whatever he's saying, it's not I intentionally stole it.
I think what I will state this by way of background, Mr. Aaron is 19 years old and has never been in a court of law
The
before.
truth is the truth. I don't care what he is. He's old enough to know truth versus lie. And if he's telling me the truth, that he didn't mean to steal it, and that this whole story just happened the way it happened, but he never intended it, let a jury decide that.
Okay.
That's the only thing he could do.
Okay. Can we?
Because I'm not gonna do a bench trial, because I don't believe it. I'll tell you that right now. I do not believe that story. So that has to go to a jury.
Okay, then let's get a date.
Okay.
No, don't say anything else.
Okay, let's set it for a jury trial.
January 7th, 8:30 a.m.
I don't think that's gonna be enough time.
Okay.
For me to.
You give me another day.
February 4th at 8:30 a.m.
That would be great.
All right, February 4th, 2025, 8:30 for jury trial. April.
Okay.
Jurors will be here at 9.
Yeah, I don't know. I've seen Judge Johnson do bench trials. I've never seen her do a jury trial. I'm gonna say that we're probably not gonna see this. I have the date written down.
Okay, we'll see you back here.
All right, this one's over. Yeah, I didn't mean to steal. I was with my special needs brother and he was having an episode, so I took my entire cart out to my car, put all the contents in my car, and then drove away while the employees were running after me. Yeah, it's a great story, man. Great story. Now, I kind of understand, you're with your special needs brother, he has an episode and you kind of chase him out. Like maybe you still like you had a basket or you had a cart and you ran out real quick, but you leave it there. You're like, oh crap, I'm still holding with the cart. And then you get him and then you're like, go back, whatever. But he unloaded the cart. But I'm with the judge. I don't believe this story at all. I can't do a bench trial. All right. Anyways, let's move on. Next one. The next one's a little bit longer. Yeah. I don't want to. I don't want to really say anything. This is just another idiot, just a court genius. Instead of calling them idiots, I'm gonna start calling them court geniuses. Okay, let's go. Judge Tammy, Georgia.
Or he does not want to resolve this case through a plea.
All right. So are you ready on to Corey Johnson, Ms. Hagler?
Yes, Your Honor, the state is ready. However, before the state proceeds, the victim in this case would like to give a proffer. So before we proceed.
In which case, Johnson?
Yes, Your Honor. And
All
then
right.
we'll have an announcement after that. I believe
Okay.
she is on the call, Ms. Woods.
All right, so this is the state of Georgia versus Corey Johnson, 2022 CR 06588 for battery family violence count 1, battery count 2, simple battery family violence count 3, simple battery count 4, and cruelty to children count 5. And go ahead, introduce your witness.
Yes, Miss, at this time, the state would like to introduce Miss Fashana Woods. We cannot see you, Miss Woods.
Yeah, Ms. Woods, I need some light on your
You're
face.
dark.
I'm sorry.
Okay, a lot better. Is Ms. Woods, at this time, it's my understanding that you would like to put a statement on the record regarding this charge and the current charges?
Raise your right hand for me.
Oh, sorry.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Go ahead, Ms. Hagler.
Yes, Your Honor. Ms. Woods, it's my understanding that you would like to put a statement on the record regarding the charge on the calendar as well as the new charge regarding Mr. Corey Johnson?
Yes.
Okay, and what is that statement? Oh, I'm sorry. Before you give that, can you please spell your first and last name for the record?
Yes, ma'am. F-A apostrophe capital S-H-A-U-N-A. Last name Woods, W-O-O-D-S.
Okay, thank you. And what information do you want to put on the record regarding these cases against Mr. Johnson?
Yes, ma'am. For both cases, I was asked how I wanted everything to play out. I did want everything to be dismissed. However, I am needing help with our children. It's taking a toll on our children. Like I just want my family back. I just want everything dismissed.
What is the relationship between you and Mr. Johnson?
It's my children's father.
Okay. And why do you want the cases dismissed against him?
Because he's not guilty. It's like it was kind of much more than what was mentioned. Other people were involved. It was just a lot. And at the time I was pregnant, it was just a lot going on. And I don't want to see him in this position. Like I said, we have 5 children and I do need help with my children and I don't have any other help. And he is the help. And we just want him back around. Like it's taking a toll on my children as well.
Okay, and you mentioned that he is not guilty. So are you saying that?
All right. I hope I'm not the only one that thinks this, but every time I hear somebody, it doesn't matter court, in real, it doesn't matter where I hear it, but whenever I hear it, it's more, they're more than meets the eye, or it's more than meets the eye. I really want the Transformers noise just to come in. Oh, that was terrible, but I think you guys know what I'm talking about. Every single time, I'm expecting that sound effect. Maybe I'll do it, because I hear it all the time in court. Maybe I'll clip that just so I can play it. I can't be the only one that thinks that.
These charges were not true charges at the time of the incident?
Yes, ma'am.
So you're saying that you lied to the officers when you brought these charges? Or
I would say I wouldn't say lying. I would say that I wasn't even the one that called the police. It was actually someone that he was dating, and I had a altercation with this person, some stuff going on with this person, and that's kind of how everything played out.
Your Honor, I don't have any further questions for Ms. Woods.
I do. Ms. Woods, you have 5 children with this gentleman?
Yes, ma'am.
How old are the children?
14, 12, 10, 3 and 2.
Okay, and y'all's relationship is not stable enough for y'all to have ever considered getting married?
Yes, ma'am. We actually been together off and on since we were 14. Like, I know this man, and I don't want to see him in any trouble, ma'am.
I get that, but ma'am, sometimes people can be bad and wrong, and we still love them and don't want to see them in trouble, but they're still bad and wrong. I mean, he has several cases before this court too for the same thing, if I'm not mistaken. So either y'all are a toxic relationship and shouldn't be together, or something's wrong.
Yes, ma'am.
I mean, you have children, you have 14-year-old, you have teenagers, people who are going to be going into relationships with other people at some point, and you and Mr. Johnson, this is the best y'all can do? But you want to let him off the hook? Let me ask you this question. If one of your kids messed up, would you just say, no, it's no big deal, let's let him off the hook?
No, ma'am. I would talk to my child. We will find another option. It wouldn't be anything to harm his child.
And so you think holding Mr. Johnson responsible for his actions as an adult man is being harmful to him?
Ma'am,
I'm trying to figure out, like, what's the example? Like, he gets off because you're going to dismiss everything. And I know he did something. I don't know what he did, but we got 2 cases here, and you're telling me something happened. But you just want to let him go free, but you wouldn't do the same thing with your kids. Mr. Johnson, uncover your face. You in a car. Yeah. So you willing to let him off the hook because you need him to help pay bills. But if your children did something wrong, you would discipline them.
Ma'am, I will treat him the same as I do my children, ma'am. Because I love my children and I love him. Yes, ma'am.
Because so if your children do something wrong, you're just gonna let them get away with it?
No, ma'am.
Okay. Then what I'm saying to you is Mr. Johnson needs some correction. Because I'm looking at this and it says battery, family violence, battery, simple battery, family violence, battery, simple battery, and cruelty to children, which means that one or more of the children that y'all share witnessed this. And I'm so tired of people thinking that kids aren't affected when they have issues in their relationship and there's raised voices, there's yelling, there's screaming, there's cussing, there's violence. That the children aren't affected, and then, oh, we need help with the bill, so let's just get back together. Because that's not you're not the only victim. Your children don't get to speak to me today, but this says that there is a minor under the age of 18 or more than one who needs to talk to me about the fact that a crime may have been committed against them.
Are they able to speak with you?
No. I'm not going to have you coerce your children into telling me they want daddy home. because there's all kinds of reasons for that. That doesn't mean daddy doesn't need to be disciplined. I'm just saying, Ms. Woods, sometimes you got to think about the quality of the relationship you're in and whether this benefits your children, not whether it benefits you, because you're grown. You've been with him and putting up with him since y'all were 14. He's been with you, putting up with you since y'all were 14, but y'all have 5 children now. And sometimes you have to determine whether this is the right relationship for your children. Not just because of a financial motive. Yeah, we need daddy back because he pays the bills. He should have to do that anyway because he's got 5 kids. He should be doing that anyway. Mr. Johnson, uncover yourself. What is wrong with you? Take the hat off. Take the scarf off. Oh, don't act like you don't hear me because I'll find you and then you can do that in front of me.
It's not no scarf. It's not no scarf. It's my clothes.
It's your who? What?
Mr.
I can't take it off.
Well, pull it down because you keep covering your face.
This a sweater. This is not no scarf. I can't take it off. This is clothes.
Pull it off your
face.
Not
no scarf.
Pull it off your face.
It's down.
All right, so she's put it on the record, Ms. Hagler. Go forward with the hearing.
Can I ask Ms. Woods a few questions, please? Just briefly, Ms. Woods, you're aware that there are 2 separate cases pending where you're the named victim and Takori Johnson is the defendant?
Yes.
Okay. Are you aware that one of these cases allegedly happened July 13th, 2021?
I don't recall the exact date, but I'm
okay. In that case, Mr. Johnson is charged with grabbing you by your hair and forcibly pulling your hair until your hair was removed from your scalp. And earlier you stated that Mr. Johnson was not guilty. Are you saying he did not commit that act?
No.
I'm sorry, you're saying
I'm saying that he's not guilty.
And he did not commit that act?
No.
Are you aware that and he's charged with a offense that allegedly happened on the 11th day of February 22. He's charged with striking you with a closed fist about your body. Are you saying that that never happened?
No.
So is your statement that that did or did not happen?
Did not.
Okay, no further questions.
Ms. Woods, please be mindful that I swore you in at the beginning of your testimony. And if the officers testified to anything or show me pictures that are different from what you testified to, you could be subject to the offense of perjury, which is punishable by up to 5 years in prison. All right, so now let's go forward.
Yes, Your Honor. At this time, the state would like to call Officer
Mr. Johnson, I can't see you. I need to see you throughout this hearing. I need to see your face. Thank you.
Time, Your Honor, the state would like to call Officer Zany Billingsley.
Officer Billingsley.
1 second, Your Honor. One second, Your Honor.
All right. Had to fast forward there. The officer, I don't remember what happened. He wasn't on Zoom or he stepped away for a minute. So there was about a 20-minute gap in between what happened and now. Yeah, he's about to testify. Now, he is testifying to something that's a couple years old. Also, this is messy. It really is. You're gonna find out why. But just this entire hearing is just a mess. Okay, let's go.
All right, are we ready to move forward on the,
Just got an indication that Mr. Moody might be sending James Bowles over here.
and then who?
Mr. Bowles works with Mr. Moody. He's one of
Okay, well, then he needs to get here soon because Miss Stanford has to get to class. And so I start at 10. I don't know what schedule Mr. Moody's on.
Thank you, Judge. I'm just.
All right. All right, Ms. Hagler, are we ready on Johnson?
Yes, Your Honor, I believe Officer Billingsley is on the call. Okay, he is on. Officer Billingsley, can you please unmute your camera and your speaker device?
I don't know if it gets better or worse. I was saying it's a mess because nobody's ready for this hearing. Nobody is. The prosecution is struggling. The defense is having tech issues. This entire hearing is a mess because you'll be able to follow along and it's worth watching. It's kind of how do I say it? Let's just say judge is probably taking some ibuprofen after this hearing.
Okay, he was on.
Out of Alabama as of 2014.
There he is. All right, Officer Billingsley, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. Ms. Hagler, your witness.
Thank you. Please state your first and last name for the record.
Officer Zany Billingsley.
And can you please spell your first and last name for the record?
First name is Zannie. Last name is Billingslea.
And how are you employed?
A police officer with Clayton County Police Department.
And were you employed with the Clayton County Police Department on February the 11th of 2022?
Yes, I was.
Okay. And did you respond to 240 Flint River Road, apartment 5, Jonesboro, Georgia, 30238?
Yes.
And what county is?
All right. Before we really get into his testifying or his what word am I looking for? Testimony. There we go. Before we get into his testimony, before we get into his testifying. Why are words always so hard? Biggin, thank you so much for the raid, my friend. I appreciate it. Welcome to all the Biggin Raiders. Let's see, how do I catch you up real quick? So this is a hearing where the victim is saying that, okay, so this is a domestic violence case, some kind of battery charge. The victim is now saying a couple years after the incident that it never occurred. Like, oh, it didn't occur. He's innocent. Please drop the charges. So the judge decided to have a hearing, called the arresting officer in, which is this guy, and now they're going to have a hearing and take testimony on if this event actually happened or not. And judge did threaten the victim with perjury if it comes out that that she was lying. And the basis of this hearing, though, like while they're in court, is I think it's a bond. No, it's a probation violation because there's supposedly contact between the two of them. That's why we're here. So that didn't even really come up at all. They went straight into the hearing because the victim could be like, oh, it didn't happen, but they're here for probation revocation. They want to take them away. All right. I think I caught everybody up. Biggin, you are awesome. Thanks again for the raid, my friend.
That location located in?
Clayton County.
Your Honor, let the record reflect that venue has been established.
Record shall reflect that.
Thank you. And on that date, what was the nature of the call?
Give me 1 second.
Okay.
Hey, Pierre, thank you so much for the gifted membership. I appreciate it.
We did say
Welcome to the
February
new
the
member.
2nd?
February the 11th of 2022.
February the 11th, okay.
Yes. What was the nature of that call?
I would ask that the officer testify from personal knowledge unless it's been established. Remember, that's been delayed, but just look
All
at-
right, Officer Billingsley, answer the question. If you don't know, then you may be able to refresh your recollection after that.
Okay, it was dispatched as a domestic call.
Okay. Do you remember specifically what was said about that domestic call?
No, I don't have the report. I'm looking at the report as we speak. I
Okay.
got blindsided. I didn't know about the case until a minute ago.
Okay. When
Yeah, this is what I was saying. They're not ready for this. The hearing, it's frustrating. It's frustrating. Real quick, Raul, thank you so much for the super chat. I appreciate it. For the Benineers? No idea what that word is. But thank you for the super chat. Are you trying to say bigoneers, maybe? I don't know. I don't know. But thank you so much. I appreciate it.
you arrived on the location, on the scene, do you recall making contact with any or speaking to anyone when you arrived at the location?
Did you need a moment to refresh your recollection, sir?
Yes, give me a moment.
Okay.
When you finish refreshing, just look up and let us know.
Okay.
Yeah, he's got the report right in front of him. What's up, Katie? How are you? Too many clicks. Yes, Biggins friends. Bigoneers. All right, I like it. I like it. Bigoneers. I'm gonna use that. Thanks, Ro. I shouldn't have paused it a second ago to thank you, Ro. I should have just waited till this. I knew this was gonna happen. This isn't the first pause where he has to read the report. Thanks, Phil. Cue the Jeopardy music. You definitely don't want me to make the Transformer noise again. At least Ed doesn't. Everyone else laughed. Ed was about to leave. Come on, officer, read faster. Dead time is painful. Yep. You know what's gonna happen? If I go to fast forward, I'm gonna have to rewind. He doesn't take that long.
Jan, I'm not able to pull up that report just yet. The report's not coming up.
Wait a
All
second.
right, Ms. Engler?
What were you doing for the last 2 minutes?
1 second, Your Honor.
Is it possible for you to forward me a copy of the report?
Yes,
I
we're gonna try to
was
forward.
just notified about the case about 5 minutes ago, so I wasn't aware. So
Yeah,
I
we're
didn't
gonna try to
prepare.
forward it to you. Let me get with my investigator. Give me 1 second.
All right.
Officer Billingsley, it's one in your email.
One email? Okay, I
It's in
check.
your email. Mhm.
Thank you, Chief.
Yeah. And Judge, I mean, you know, I do have to object. I mean, right now we're in the middle of testimony. The witness is not prepared to testify, and now he's reviewing his report before it's been established that, you know, his recollection needs refreshing.
Well, actually, sir, he did say that he needed to have his recollection refreshed because he said that up front.
Right.
That he wasn't aware of this case. When he went to look, he asked to be able to review. So he did say that. I'm sorry.
But my understanding, Judge, is that would apply to, you know, each individual question, not that, he can just take time out in the middle of the hearing to just,
I agree with you, sir. I definitely agree with you on that. And I'm not quite sure why we have motions on the calendar that we're not prepared for. Ms. Hager?
Your Honor, I am prepared for, and it was just a misunderstanding as far as which officers need to be contacted for the newer cases.
I was wondering where the defense attorney was during all that. He needs to speak up, say something. This doesn't seem right to me. Unprofessional at the least.
All
Say
right,
something. And then he did. What's up, Shaw? Good to see you. Yeah,
Okay, I'm back.
like I said, painful.
When
It's
you arrived on the
painful.
scene, did you make contact with anyone?
Yes, I made contact with the victim.
What is the victim's name in this case?
The victim that I spoke with on that date.
And again, Judge, I object. I mean, he's just reading off his report, and there's no. She continues to ask questions, and his answers are just to look at the report and read it. She's not asking him if he remembers, and it's not being established that his record needs to be.
All right, Ms. Hagler, he's got to speak from his recollection, even if it's got to be refreshed. We got to get that he needs to have his recollection refreshed.
Yes, Your Honor. Officer Bensley, do you need to have your recollection refreshed as far as the name of the victim in this case?
Yes.
Okay. Do you have your report in front of you?
A Woods subject.
Okay. Do you have your report in front of you, Officer Billingsley?
Yes, I have access to the report.
Okay. Take a moment to read through, and then once you've located the victim's name, please let me know when you're ready to proceed.
Yeah, I'm ready to proceed.
Do you recall the name of the victim that you spoke with?
Woods.
And first name?
The first name, I can spell it for you.
Okay, you can spell it. That's fine.
First name Fahashauna.
Okay. And doing your investigation, what did she tell you what happened?
She stated that her live-in boyfriend, she referred to as Mr. Johnson, reside with her, and they have several children together. They live at the same location. She said they had a dispute over a cell phone, being text messages on the phone. And once she was able to unlock his phone, she saw that other females had been texting. The two got in a dispute. He became angry. At that time, he lashed out toward her, hit her in the upper body with closed hands, closed fists, and around her neck, leaving visible marks on her body. And then at that time, he took a car key and took a door key, and also left the premise. And she stated this incident occurred in front of the children.
Okay, now you said that you saw visible injuries. Where did you see the visible injuries?
Give me 1 second.
Do you need to have your memory refreshed?
Yes, give me 1 second.
Okay, so once you're done looking at your report, let me know when you're ready to proceed.
He threatened her. I'm not going to tell you what. Oh, excuse me. I'm not going to tell you what happens, but she did threaten her. The judge did threaten the victim. And yeah,
I'm ready.
Okay.
All right, real quick. There's been a couple people that said, why don't they just ask for a continuance or adjourn this till another day for all the parties to be ready? This is a probation revocation hearing. So it's probably up there with this needs to kind of happen now. Also, with the victim there speaking and the judge threatening her with perjury, I don't think the judge is going to let this just slide. I think that's why she's giving them a little bit of grace for not being ready. I know she called her out, but she could have just been like, "Nope, we have too many people on this docket. We're not doing this. I'm giving you a new day. Be ready." She could have done that. She didn't.
Where did you see the visible injuries?
Scratch marks up around the neck.
Okay. Did Miss Woods inform you of if she was hit anywhere else on her body besides the neck area?
She said the stomach area. She said she was also 5 months pregnant, and she later stated that she was bleeding in her vagina.
Okay. Was medical called out on that day?
Yes.
Okay. Do you recall if she was taken to the hospital on that day?
I have to refresh my memory on that, but medical.
Okay.
Give me 1 second.
Okay.
No, on the date in question, she declined to be transported.
Okay. Okay. And you mentioned that there were children present?
Yes. And
Do
the
you
children
recall?
belong to them both. She said 3 of the kids belong to her and her boyfriend, Mr. Johnson.
Okay. Do you recall the age of the children during
Yeah,
that time?
I need a moment to refresh my memory. It's in the report, the children information. Give me 1 second.
Okay.
Yes, I show the children age to be age 7, 11, 9, then also an infant child.
Okay. So they were all less than 18 years old?
Yes.
Okay. You mentioned that something was taken from Ms. Woods. What was taken?
Key.
Okay. Were you able to determine the value of the key at that time?
She said it's just a duplicate key, so roughly $5 perhaps.
Okay. And what was this key to? What did it go to? What was it for, if you remember?
Yes, give me 1 second. First memory.
Are we still here? Can y'all hear me?
Yes.
Yes, we can hear you.
Okay, we're having some technical difficulties on my end. I don't know what this screen is.
Okay, I'm back.
Okay, what was the key for?
Okay,
What did it go
actually,
to?
she indicated several keys, door key as well as a car key. So I had the value listed at around 150.
For both keys,
Guys.
door key and
All right. Guys, everyone pause. The defense attorney just said he's having technical difficulties. We don't know what they are yet. And you guys are just like, just ignore him. He'll be okay. This entire hearing, man, so frustrating.
Door key as well as a car key.
door key and car key. Okay.
Yes.
Okay. And I believe you said that she told you the defendant left the scene,
Yes.
so he wasn't there upon your arrival?
He was not present, correct.
Okay. And you said that the last name was Johnson. Do you recall the first name of the defendant?
The first name I can't pronounce, so I'll spell it for you.
Yes, if you can spell it for me, that'd be good.
The first name spelling Tecorey.
Okay.
Corey, perhaps.
Okay. And Officer Billingsley, do you see that name anywhere on the Zoom? If you scroll through your Zoom?
Do I see? Yes, I see the offender name on Zoom now.
Okay. Your Honor, record reflect that officer has identified the defendant by name for this case.
Record shall reflect that.
Thank you. Officer Billingsley, how did you conclude your investigation?
Once I arrived on the scene and did a safety check, found the defendant wasn't there. At that time, I provided aid to the victim. Once she received aid, I got statements from her, verbal statements. They was all recorded on body camera, and made sure the children was okay. And then once I got all the information and ensured that she was okay, the victim was okay. At that time, I later took out warrants for the offender.
Okay, and what warrants did you take out from the defendant?
It'd be the battery, because that was visible signs of injury. It'd be because they were related as far as having children together, living in the same household, falls up under family violence. So simple battery, family violence, cruelty to children, and also theft by taking for the two keys, and also assault on an unborn child because she was 5 months pregnant at the time.
Okay, and why was he?
Miss Hagler, 1 second. Mr. Johnson, Miss Woods, I don't care if your video is on, but Mr. Johnson, your video has to remain on during the course of this hearing, sir. Please don't make me tell you that one more time.
And Judge, just for the record, we're in the courtroom. We're experiencing technical difficulties. I can't see anybody. I can hear what's going on, but there's, a sort of an error message. It's just showing the Clayton County logo.
Yeah, that I see you just fine. So it's Clayton County that's having that issue, not Mr. Johnson.
Well, I understand that. I'm just saying from my end, I cannot see anything going on.
Okay, well, I see y'all just fine in the courtroom, so you might want to see if it's just that your video is not on, or if the.
Okay, we have IT coming in.
Okay, is it on both screens, the error message?
Well, yeah, I don't know if it's an error message, but neither screen is showing the Zoom meeting. All I can do is hear.
Okay, well, we see you just fine. All right, go ahead, Ms. Hagler.
Yes, Your Honor. And why did you take out warrants for the cruelty to children?
Because the children were present during the admission of the crime, being battery.
Okay.
Family violence.
Okay. Your Honor, I do not have any further questions for Officer Billingsley.
I have one question. Officer Billingsley, you stated that you had body cam operating at the time.
Yes, we should have body camera footage.
And the body camera footage would have recorded the statement made by Ms. Woods?
Correct.
And it would have shown her telling you the injuries that she suffered?
Correct.
And it would have shown the statement that she made regarding what she alleges Mr. Johnson did at the scene?
Yes, the body camera footage should show everything.
All right. All right, Mr. Lynch.
Yes, Officer Billingsley, you testified that Ms. Woods informed you that this argument started when she observed a text message on my client's phone that was evidence of infidelity. Is that correct?
I can't say infidelity or not. I can say she was disturbed by text messages on the phone.
Okay, so she saw some text messages on her phone that made her upset. Would that be fair to say?
Correct.
Okay. You did not observe my client on the scene at any point, correct?
Correct. I didn't observe him on the scene. I never spoke to him.
You never spoke to him on the phone, correct?
Correct.
So that's all the questions I have for Officer Billingsley at this time.
Anything else, Ms. Hagler?
I'm not for Officer Billingsley.
All right, do you have anything else for this officer? Can he be excused?
Your Honor, he can be excused.
All right, thank you, Officer Billingsley. Be safe.
All right, thank you, Judge.
Thank you, Officer.
Judge, I'm not sure what the state is trying to do next, but I have someone with the
Hi, Miss Crystal.
trying to help us with the computer here.
Miss Crystal, I can see y'all just fine. Mr. Lynch says y'all can't see anybody.
Okay, got you.
All right, does the state have another witness?
At this time, Your Honor, the state is going to rest. However, Your Honor, I'm sorry. Before the state does rest, I do want to put on the record and request the court take judicial notice of an order for bond that was signed by Judge Stephen N. Knights Jr. on June the 5th of 2022.
I would object. I think that can be introduced into the record, and I mean, it's attached to the motion as an exhibit, so I'm not sure why judicial notice would need to be taken.
Well, yes,
All
it is
right.
attached to the motion. So you do have a copy then.
Okay, what, on the bond conditions, can you read to me who he is prohibited from having contact with?
So yes, Your Honor, on this particular bond condition, the defendant was prohibited from having contact with, I'm sorry. One second, Your Honor. Okay. So, misspoke. The order was signed on July 27th of 2021, and he was prohibited to stay away absolutely directly or indirectly by mail, email, pager, telephone, or third person from the person, home, work, place, and immediate family members of any witness, including but not limited to Vashana Woods.
Okay. Any objection, Mr. Lynch?
No, Judge.
All right. All right, so the state is rested. Did the defense have anything that they wish to present on behalf of Mr. Johnson?
Judge, we're not going to present any evidence today. I just would like to make an argument.
All right. State may go first, or did you wish to? It's up to you.
I can go after the defense, Your Honor.
All right, Mr. Lynch.
Judge, I believe that there's case laws that supports the contention that one of the things you can take into consideration when making a decision on bond is the likelihood of success at trial. Putting that aside for a moment, of course, you as the finder of fact have to determine the credibility of the witnesses. This own court has called Ms. Wood's credibility into question. She did set up here and testify that these events did not happen the way that they are alleged. And, that's what a trial is about, is to get to the bottom and to get to the truth of what actually happened. The officer is not able to establish that Mr. Takori Johnson was actually at that residence. Only evidence of that would be hearsay through, which I understand may be admissible in this proceeding, but its probative value is basically nothing.
It's not hearsay if a direct witness to the event testified and Ms. Woods testified.
She testified, well, I didn't hear her testify that he was there at that day. She just said it did not happen. That was what her testimony was, Judge.
I get that, but the other side has an opportunity to rebut her testimony, but it's still evidence. It's not hearsay.
Well, I think my contention was that the statements about what happened would ordinarily be hearsay in this, and she didn't test it. And either way, she directly contradicted them on the record here today and said that these events did not happen.
Okay, but what she did not say was that he was not there.
She didn't say he was there either, Judge. And so, Judge, additionally, I would point out that this allegation that allegedly violated his bond took place February 11th of 2022. We are now days away from going into the year 2025, and this motion was not filed until very recently. And during the interim, Mr. Johnson has not picked up any additional charges that have been presented to this court. There have been no additional issues with his children or Ms. Woods. Ms. Woods obviously does not want his bond response, these cases to be dismissed, and for Mr. Johnson to be able to resume his role as, providing for their children that they have in common, Judge. And so we are respectfully requesting that because of the because of the flat denial by the victim, that you take into consideration that, this is on the record, and the likelihood of success at trial is something that you can take into consideration, whether or not she's perjured herself or not. That's not something that I can know or you can know, but the
What
credibility.
are the Ayala factors, Mr. Lynch?
Judge, the Ayala factors are likelihood of flight, which there's been no evidence that he is likely to flee. He has likelihood to commit additional or likelihood to commit felonies while out on bond, while there's been no suggestion that he would commit felonies or no evidence of him committing any felonies.
Except, well, not felonies, but the allegation of battery against a pregnant woman is a misdemeanor of a high and aggravated nature.
Understood, Judge.
Right, continue.
What am I, I believe the seriousness of the offense is one of the factors.
Serena, that's my fault. I actually said it was a probation violation hearing. I did not say bond. My mind was this happened almost 4 years ago. There's no way he's still on bond. There's no way this is 4 years old. It is. It is a bond hearing, not a probation. So that's my fault. I gave bad information. Real quick, Mimi, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Mimi. Also, Sparkle Poops. Find this Leo and give him this copy, maybe. Yeah, I'm not mad at the officer. It wasn't his fault. He was ambushed by this hearing. He had no idea. It's on the prosecutor for that one. They got through it though. We crawled through it, but it was ugly.
Which I just stated, battery on a pregnant woman is a misdemeanor of a high and aggravated nature. Go on. And the likelihood to contact and tamper with witnesses.
Correct, Judge. And
All right.
I'm sorry, my memory was failing me as to that factor, but Judge, again, I don't believe that there has been any evidence that establishes that that is the case, especially considering the credibility issue that's been established as to Ms. Woods.
All right, Ms. Hackler?
Yes, Your
I'm
Honor,
sorry.
briefly, Your Honor, we just ask that you revoke the defendant's bond, that he was given an order to not violate any laws or to have contact with them in this case. And per Officer Billingsley's testimony, he did have contact with her on February the 11th of 2022. Specifically, he caused injuries to the victim that were visible to the officer while on the scene. And not only that, he did commit the offenses of battery, family violence, theft by taking cruelty to children and assault on an unborn child on that day as well. So based on officer's testimony, we just ask that you revoke the defendant's bond.
Now, normally I would say it's been a long time. He doesn't have any additional offenses. I'm kind of on the fence, but this is the issue that I have. I think that I just really feel like the testimony that Ms. Woods gave, I really feel like Mr. Johnson is still in the home. He's still there with her, currently violating the court order. So at this time, I feel like the factors have been met. Mr. Johnson had a bond order of July 27, 2021 that said he wasn't to have any contact with Ms. Fashana Woods. On July 11, 2022, her initial allegation was that he came back to the home. She reported this to the police. She called the police, first of all, and then reported this to the police that he beat her about the head and body, took her keys, her car keys and her home keys, left, and this occurred in front of the children. And there were visible injuries, and at the time that she was pregnant. So it seems like Mr. Johnson leaves Ms. Woods with babies, and then he's out here doing what he want to do. So at this point, the court finds that there's sufficient evidence to establish that Mr. Johnson has violated his bond conditions in this case, and he should be taken into custody until such time as his cases are resolved.
Thank you, Judge.
You're welcome.
And that is it. That is it. No comments from the defense or the defendant. She didn't even acknowledge the victim that she threatened with perjury. Nothing. All right, hey, Mr. Sweater dude that keeps covering his face, who gave some attitude earlier. You gotta turn yourself in. You're going to jail. Bye. That was it. Yeah, that one was tough to watch. All right, we got one more. We're going to jump to Judge Perkins, and yeah, we're going to see Judge Perkins get a little frustrated. Am I caught up on everything real quick? I am. All right, let's go.
Yes.
Oh, I feel like something's going to happen. That entire hearing was ugly from start to finish. It was bad. Yeah, I don't know. Something's going to happen.
Do you know what your client wants to do? Yes, Your Honor. My client would avail himself of the people's offer to enter a plea to failure to display. Raise your right hand, sir. You swear or affirm to tell the truth, whole truth, nothing but the truth? Yes, Your Honor. All right, you can put your hand down. You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines? Yes, Your Honor. You understand that you have an absolute right to a trial? Yes, Your Honor. Mr. Berry went over your other advice and rights to break out home, did he not? Yes. You understood those rights? Yes, Your Honor. Any questions about those rights? No, Your Honor. Nobody taking this deal, you're gonna give those rights up? Yes, Your Honor. Has anybody offered you anything other than what's been stated in the record? No, Your Honor. We draw your attention back to August 23rd, 2024, around 8:04 a.m. in the city of Detroit, in the area of Cashew and Merlin Street. Were you in that area around that date and time? And yes, Your Honor. Yes, Your Honor. You, sir, you stated to the police department that you were carjacked? Yes, Your Honor. What possessed you to say that? To get the police out there sooner. I had my work vehicle. It was actually stolen. Okay, so you're gonna go and take away from the resources for you because your vehicle was stolen, and have the police probably rushing their lights and sirens on a carjacking allegation just because your vehicle was stolen. I did wrong, Your Honor. I understand.
Isn't that special? I'll answer that after this clip. I don't want to pause it for too long. This one's not very long.
It won't happen again. Accept this offer. See how selfish people are nowadays? Super, super duper selfish. Your Honor, I apologize. It's not going to happen again. I've heard you apologize already. You've already said that. But this is just what the problem of this world is. Me first, me, my stuff is more important than anybody else's stuff. That's what your thinking was that day, right? Yes. No regard for anybody else that's going through a traumatic situation, and just using the resources right up for Mr. Giannone. I panicked, Your Honor. You didn't panic. You didn't panic. Now you keep on talking, and I'm not going to accept this offer. It was not a panic. It was you were mad. And you knew that by saying that was going to put you right at the front of the line. You absolutely did not panic. And you're very, very lucky that this is the only thing that they charged you with. You are admitting to a capital offense that you alleged had happened. Where is Ray, Michigan? 28 Mile in Groesbeck. It's Macomb Township. All right, it's gonna be the sentence of the court that, you're gonna pay $240, and you're gonna do 40 hours community service in the city of Detroit. I need a good phone number from you.
586 612 612 0990.
I'm gonna give you the number to Ms. Green. I'm gonna refer this to the community court.
I'm ready.
Coordinator, Ms. Green, 313-96. You shouldn't have to call her, she should call you.
Yes, Your Honor.
I'm gonna set this matter for review in 30 days on January 9th, 2025. Ms. Green, I just gave you the number. If she doesn't get in touch with you in the next week or so, you need to reach back out to us. And $240 is gonna be the fine. You can pay that at that kiosk in the city of Detroit, or come on down to the courthouse and pay it in person. Your next court date is gonna be January 9th, 2025 at 8:25. And we're gonna put that referral in, so keep your lines of communication open and wait on Ms. Green's call, all right?
Yes, Your Honor.
All right, if there's nothing further, have a safe and happy holiday season. I'll see you back on January 9th.
Thank you, Your Honor.
All right, that one's over. What I was gonna answer something real quick. Oh yeah, real quick before I answer that, isn't that special? Yeah, Judge Perkins is not happy with this guy at all, and I don't blame him. I mean, he did. My car was stolen. I'm gonna call the police and say I was carjacked instead. There's a big difference between those two. He could have played. He could have acted ignorant, like, oh, I thought it was the same thing. No, it's not. It's not, and I'm sure they made that very clear when he called 911. Yeah. Yeah. Anyways, let's move on. Isn't that special? Um, so Judge King is in traffic court right now. Let's see. Judge Sabri took his seat. Judge Taylor took Judge Sabri's seat, and Judge King took Judge Taylor's seat. He's not on YouTube now. He's hoping to be back in his seat come the first of the year. That's what he told me when I was there in person. When was that? 2 months ago? Month and a half ago? I don't remember the last time I was in Detroit. I've been to Judge Simpson's courtroom about a dozen times since I was at last in Detroit. Somewhere around there. So that's what's going on with Judge King. I need to check in on him. I haven't talked to him in a little bit. Yeah. All right. You guys want to watch the Judge Boyd thing real quick? See if I can't get it up. I don't know if I'll be able to. That sounded terrible. 'Cause I haven't clipped it and I haven't edited it yet. So I'm gonna see if I can't just share my screen. I might not be able to. That's how I should have said it. Let's see, share screen. Okay, it's letting me. Okay, we'll watch this Judge Boyd clip before we head off for the day. How do I? It's not letting me play it because. All right. Is it playing on your guys' side? It shows that the video is paused. Is it even playing? I might not be able to do this. Because I can hear the video, but it's not actually playing. You can see it. Let me try it again. I'm gonna stop sharing. Start again. I might not be able to do this. I might just have to add it to a video tomorrow. All right, let's try again. Stop. Is this working now? All right, I'm not gonna be able to do it then. I'm trying to just share my screen and play it off of my media player because I haven't compiled it yet. So the format of the video I can't upload it into StreamYard. So I'm just gonna have to put it in a video tomorrow. I don't know another way to do it. Yeah, and it's gonna I mean it's gonna take me probably 10 or 15 minutes to compile it. So yeah, we'll just wait till tomorrow. We'll wait till tomorrow to play it. It's fine. I'll bring this back up. Stop sharing. All right. So I guess that's it then. I don't have anything else. Yeah, I saw that he did the video. I didn't see that he got worked up. I didn't watch it. I generally just skim what other court content people do just so I see what videos they're doing. So the way that I do it, when I see someone else put a video out, I will so I already had this clip, right? So I don't want to put a video out just with this clip because it's already been on another channel. So I'll generally just add them to my live. So a lot of my lives clips have already been seen because other people have put them out. But that's generally how I use those clips. We'll just watch them live instead of a standalone video. So when I saw him do that, I was like, oh man, my video is already made for tonight. So it looks like my clip for tomorrow I can't use. So we'll just do it tomorrow. It's fine. It's fine. All right. Let's raid somebody. We gotta raid somebody. But that was supposed to be the bonus clip, but can't do it. But I learned can't do it that way. Who are we gonna raid? All right, looks like we're going to Lone Wolf. All right, thank you guys so much for hanging out with me tonight. I do appreciate it. Sorry, the last 5 minutes has been a little let's just say my tech skills are coming through, shining bright right now. You guys are awesome. Thank you so much for hanging out with me. Thank you for the super chats, the gifted memberships, membership milestones. You guys are awesome. Have a great night. Go jump over, tell Lone Wolf I sent you, tell him I said hi, and as always, tell him that I am a better YouTuber than he is. He loves hearing it. It always makes him smile. I will see you guys tomorrow night. That Judge Boyd clip will be part of my live stream tomorrow night, so you have that to look forward to. And yeah, until next time, bye.
Have a great holiday as well.
All right, Mr.